as I mentioned, I wanted to start with Kyle Rittenhouse. Kyle Rittenhouse is a story that we've been following here for a long period of time. Very young man, 17, I think he's 18 now, and he was involved in the Kenosha shootings that took place in Kenosha, Wisconsin, mid last year. This was a story of sort of some protesters, Antifa, BLM, kind of an amalgamation of a number of people going through Kenosha. Kyle was 17 at the time, had a firearm, was there to protect some property and some business, sort of was getting attacked and, run down by one guy, turned around, shot him a few times, and then the mob descended upon him and he was sort of running away and shot another person, killing him, and then shot another individual, just wounding him. And so for a long time, we've been covering this story to see what's going to happen to this kid. When we were analyzing it back last summer, we were talking about self-defense, and in my mind, it was a pretty clear-cut case of self-defense. We talked through the probable cause statement. We looked at some maps. We looked at some video compilations. We reassembled a lot of data on that. And now we've just been kind of following it along. I want to see where this goes. I think this has some pretty big implications for gun owners, for people who are self-defense advocates, for people who don't rely necessarily on the government to, answer every single problem for them. People have guns and they want to protect themselves. That's why the Second Amendment is the Second Amendment. It's really close to the beginning of the document because it's that important. And so we want to see where this goes. And up until this point in time, I have been pretty disappointed with some of his defense counsel for months. I thought he sat in custody unnecessarily. They were trying to prevent extradition from Illinois back over to Kenosha. And now that he's been extradited, he was able to generate enough funds to post a $2 million bond. Then he got out of custody. Then, because he was in close connection with people like John Pierce and Lynn Wood and some, I think, other nefarious characters, he got sort of, roped into this. In my opinion, like I said, he's young. He's being charged with murder, several counts of murder. And I think he's, highly impressionable and somebody who could use some better counsel at this point in time. But last week or the week before that, we were talking about Kyle in the context. He was out with his mom, I believe, at a bar. He was wearing a shirt that said, free as F word. And he was doing the allegedly the white power symbol, the okay hand symbol that, is now taboo. And that was problematic. I was saying back at that time, this does not bode well for his case. This type of stuff is going to be seen by prospective jurors. Even if they go into court and they sit down and the judge says, hey, can you be fair and impartial in this case? Even if they've seen that and they say, yes, I can be impartial, subconsciously, can you really, if you have an opinion on that, can you really set that aside, or are you going to be prejudgmental when Kyle gets brought into the courtroom? So I've had a lot of questions about that. Now, some additional, and I thought that was a problem. I thought that his attorneys should have counseled him better, should have maybe kept a tighter rein on him to make sure that he's also acting appropriately, not only in the court of law, but also in the court of public opinion. This is a case that has national attention. And apparently his attorneys didn't have a conversation with him to say, hey, maybe not a good idea to go out there and poke your finger in the eyes of the media. Now, I'm not saying that was Kyle's fault at all, other than the fact that he put the shirt on and went out there and was hanging around this, I would say, an unsavory crowd, at least a crowd that is not good for his criminal defense case. Okay. You can have your opinion on who he was hanging out with, whether he was doing any of the white power stuff. I don't know. I'm not commenting on that. I'm just telling you that is not a good image for him in the criminal court of law. It's not good. So I was thinking that his attorneys needed to get their act together to make sure that this doesn't happen in the future. Now, today we learn a different story, that basically his defense attorneys, for some reason, failed to update his address. And what happened here was the prosecutors caught wind of that his address was not up to date. That's a problem. You have to be released when you're out of custody. They got to know where you are in order to make sure you are going to come back to court. They don't just say, okay, well, you're out on custody, go wherever you want. Fly to China, fly to a non-extradition country, have a fun day. The court wants to know, where are you? Where are you going? Where are you hanging out? And now that they were under suspicion that he, in fact, was not at the address that he told the court he was at, the prosecutors are throwing a fit over it. This story comes over from a local affiliate, WISN, says prosecutors don't know about Kyle Rittenhouse's whereabouts and they seek an arrest warrant. And this was posted out of Kenosha, Wisconsin. Prosecutors said accused, so we got a little typo there. Prosecutors accused Kenosha protest shooter Kyle Rittenhouse maybe that's not a typo. Okay, said accused has violated the conditions of his release. All right, so there we are. Conditions of his release. Prosecutors filed a motion on Wednesday saying the court was unable to deliver a hearing notice for Rittenhouse at the address he listed at his home on his release paperwork. The notice was returned to the court because a forwarding address was not known. Prosecutors then wrote in their filing that Rittenhouse failed to notify the court of a change of address or telephone number within 48 hours, and that is typical, right? If the judge releases you, you have a set release condition, and one of those release conditions is that you got to keep the court up to speed. They asked the judge to increase the bail by $200,000 for the violation, and they issue to issue a warrant for his arrest. Prosecutors said they were unable to monitor Rittenhouse's whereabouts because he failed to notify them that he moved. And in a high-profile case like this, his bond was already $2 million. And now they're asking for another $200,000. And I'm not sure what's going on with the money right now, quite frankly. This was an issue that many people were flagging long ago. They were talking about John Pierce and Elle Linwood and some individuals who were sort of managing the money. There was a lot of information about these attorneys having some serious debts and some credit problems, and potentially being accused, I don't know whether there's any accuracy to it or not, of taking that money and using it for their own ends at the expense of Kyle Rittenhouse. So I'm not sure what's going on with the money. I don't know who's in control of that. I'm not sure Kyle knows who's in control of that, or whether his attorneys do, or how that is being operated. But $200,000, that's not a small sum of money. That is a big chunk. And if the prosecutors are successful here, they're going to have to find out where to post that. Otherwise, Kyle is going back into custody. His bond will be increased to $2.2 million rather than the $2 million. Unless he posts that, there's a likelihood that he goes back into jail. So let's take a look at what the prosecutors were talking about. The address listed on the defendant's November 2020 bond listed this address, right? 286 Anita Terrace. Now, obviously, he's not there anymore. They're saying this is false. The defendant no longer resides there. On December 22nd, so just about a month later, the clerk of the circuit court mailed a notice to the defendant at that address. The notice was returned unclaimed. And I'm going to show you what this looks like from the minute entry here in a second. The U.S. Postal Service indicated on the notice that the service was attempted, not known. They were unable to forward. So the address was just not updated with the U.S. Postal Service. On February 2nd, Kenosha police detectives Benjamin Antamarian and Martin Howard then traveled to that address. At that address, they spoke with a man named Aiden Earl, who stated that he had resided there since about December 14th on a rental lease, which began on December 15th. So on December 22nd, they mailed a notice, and that's when it returned unclaimed. So he moved in like right before that. Mr. Earl produced a utility bill in his name with that address on it and stated the defendant no longer resides there. So that is the evidence that the detectives were going to bring back over into court. And the same Anita Terrace address was listed on the bond that the defendant signed on January 22nd. So he was acknowledging on the 22nd that he still lived there, even though he didn't, and the new guy had moved in. They had signed a lease on December 14th. And so, basically what Kyle is doing, and he may not have even known this, by the way, when we are in court, everybody's just signing those types of documents pretty quickly, and your attorney is the one who should read it and then tell you what you're signing. Right? The attorney looks at it. I mean, this is how we do it. I don't know how his attorney's doing it, but when I'm in court, I look at the document. I say, all right, this is all good. Yep. Acknowledge it. Turn it over to my client. Hey, this is what this says. This is what this means. Here's where you sign. Is this all correct? It's correct. Good. Sign it. Boom. Good to go. Right. So I don't know if that happened here. I don't know if Kyle was just signing documents that his attorney was shoving in front of his face, or if he, it was an oversight. It sounds like a minor deal, right? Just update his address. But it isn't in a case like this. Now we're talking about this kid going back into custody again over $200,000 because the court didn't know where he was. It's a big problem. I would say it's a borderline malpractice type of situation for his attorneys. Due to the defendant's violation of his bond condition, so he failed to correct it when he signed it on January 22nd. The defendant also failed to provide the court with a new address. Due to the defendant's violation of his bond condition, the state respectfully requests the following. And we've got some big asks here: that they issue a warrant for the defendant's arrest and then increase his bond by $200,000. Okay, it's a lot. It's a lot of money. The court orders the defendant to update his address in writing with the clerk of the court immediately. So that is pretty obvious. And I think his attorneys are already on it right now. But let me show you how this whole thing worked. So this is from the minute entries over on the court website. And it says on January 28th, there was a return of unclaimed, undelivered mail. So they sent the defendant a notice of the hearing for January 5th, and then it was returned. The court just mailed it out on their own. It came back, returned to sender, attempted unknown, unable to forward, and this address was the bad address. Then just a short time afterwards, a couple of days later, then we see a February 3rd motion, so a few days go by, and the draft of the motion to increase bond, it was filed by the district attorney's office. Then immediately thereafter, the same day, his attorney, Mark Richards, to his credit, filed an immediate response in objection to the state's motion to increase the bond. And I haven't seen this document yet. It's not been public to my knowledge. So I'm not real sure what his argument was or what his explanation was, but you can see here there is some other information. We have an affidavit from John Pierce that was also submitted on the same day. So that was his attorney, and it was his attorney. Now, I'm not sure. I don't think that he's still his attorney. I think he's sort of off the case. He's not licensed in Kenosha, Wisconsin. It's this guy over here his name is Mark Richards. And so he's the one who is officially representing him. But, John Pierce was with Kyle a lot and had a lot of pictures with him. And I think he posted today on Twitter that he's always supported him and all that stuff. So we have an affidavit filed by John Pierce. We also have an exhibit in support of the objection to the state's motion. Don't know what that exhibit was unless it was the affidavit. There was also another exhibit in support of the objection to increase the bond. Again, don't know what that is because Attorney Richards then moved to seal the record. So a motion to seal all of this stuff. And so right now it's probably sort of in limbo, kind of, on the judge's desk to decide what to do with it. There was a notice of a change of address that was also filed by Attorney Richards. So, finally he goes, okay, all done on the same day. So I shouldn't say finally, right? As soon as he notified it, then he filed these motions and he notified the court that there was a change of address. Then we move on. They're acknowledging that they received that, and they received that. And then the state is replying to the response. So the state filed the motion. Kyle's attorney Richards, responded, and now they're replying to that. So they are still in support of the motion to increase the bond. They are unlikely to revoke that, in other words. So now they're going to be fighting over bond, over $200,000, because his attorney didn't update the address, or Kyle didn't notify him. Right? I'm not sure where the blame lies on this thing, but in a situation like this, it's the attorney's responsibility, in my humble opinion. Now, this other story came over from the New York Post explaining a little bit about what happened. Kenosha shooter Kyle Rittenhouse was in a, quote, safe house due to threats, lawyers say. And Kenosha shooter isn't on the run. He's in a safe house, quote, safe house, due to repeated death threats, his lawyer said. But in a court filing this week, the teen's lawyer said he's not AWOL, but he's in a safe house. Defense attorney Mark Richards said his office spoke to prosecutors as early as November about his client moving to a safe home because he was received death threats. He says here, quote, it is noteworthy that the state has now only decided to file a motion to increase bond in this case, despite having corresponded with the defense attorney, Corey Chiarefisi, regarding the change to Kyle's residence over 2 months ago, Richards wrote. The court motion also claims that former Rittenhouse lawyer John Pierce, so apparently he's not a lawyer anymore, was told by a Kenosha Police Department captain that, quote, he absolutely should not provide the teen's actual address after he was released on bond due to safety concerns. So I think that's just bad advice, right? I mean, the court, so folks, I have a hard time thinking that this stuff is just amateur hour over there. You've got a non-criminal defense attorney by the name of John Pierce, somebody who, as far as I could tell when we were looking at John Pierce and his history, was not a criminal defense attorney. And he was sort of riding into the battle claiming that he was going to save Kyle. And, he's just been ineffective this entire time. And if you want to lay the blame at his feet for following the advice of the Kenosha Police Department, which was terrible advice not to provide, what does the Kenosha Police Department captain have to know anything about what the judge wants in a criminal case? Shouldn't, right? They're witnesses to these things. They're not lawyers. They're witnesses. The prosecutors are the lawyers for the government. The prosecutor would be the one that John Pierce should have been speaking to about this, not some random Kenosha Police Department captain. I don't care if he was the captain. Okay, it's bad advice to rely on that. John Pierce should have gotten the information from the prosecutors in this case, or gone directly to the court, filed a motion and said, Judge, look, here's the situation. Our client's getting all of this, death threats activity coming his direction. What do you want us to do? We want to move him into a secret location. Can we update you under seal? Can we communicate with you? Get the prosecutor on board to make sure all of this stuff is acceptable to the court, not just relying on sort of hearsay evidence from a Kenosha Police Department captain who, as far as I know, has nothing to do with the case. Okay, was he there? Was he investigating it? Is he the lead investigator on this case? Probably not. He's the captain. Okay, that stuff gets deferred to other people who are involved in the case. So just, disappointing all around. I think Mark Richards is doing probably what he can to clean up some of the damage, but if he has to go back into custody, that is a pretty big problem. We'll see if that happens or not. Now, Kyle's case, just to close this up, a little bit of closure, he is scheduled for a final pretrial conference, it looks like, on March 10th, 9 a.m. in front of Bruce Schroeder. Final pretrial, and then they're going to be looking at jury selection just 19 days later on March 29th. So jury selection will start. I'd be very surprised, truthfully, if this case goes to trial on March 29th, but we'll see. Typically, if you're talking about a case with this many witnesses, this many investigators, this many victims in a crime, these cases can take years. But we'll see where this goes. Maybe things are a little bit faster, a little bit more aggressive in Wisconsin than they are in Arizona. So that's the update on Kyle Rittenhouse.